Good morning. You'll have to excuse my hair. It is just not cooperating with me today. So today is going to be business structures and agencies, so it's BSA for short. And I just want to give a disclaimer that I'm not a professor currently. I am not employed by any type of school currently. I am not employed by any type of bar prep at all. This is simply a rendition of something I believe would be helpful for somebody who has to take a final exam or potentially might have an exam regarding business structures. And I was able to distill all of it down into 7 steps. I'll break down each corporation further and each step further, but the purpose of this is to make it easy to, kind of synthesize the information so that you know what to do when you are faced with time challenges and restraints. So, without further ado, there's 7 steps, okay, for any type of business analysis. The first step is going to be what is the structure of the business? Second step, who were the parties involved? Third step is going to be the duties that are owed. The fourth step is going to be what happened or the injury. What are people complaining about? Fifth one is going to be breach. 6 is liability, and 7 is remedy. So a structure, the question you have to always ask is, what is the intention of the parties? What are they trying to do? What are they trying to make? What did they want to create? What have they done so far to create that? That will go a long way in helping you figure out what type of structure it is. For example, a partnership is a structure between 2 or more individuals. Typically, a partnership is something that could be potentially perpetual in nature, meaning that it doesn't die. But most of the time, once a partner dies, the partnership also dies with it. So if you're looking at a fact pattern and something says that there was no intention of the parties for something to live on indefinitely, then you're kind of looking at more of a partnership. On the other hand, if you're looking at a business where the intent of the people that were trying to create it were trying to create something that would never die, that would continue on perpetually, then you're probably looking at a corporation. Now, on the other hand, if you're looking at, say, something that could potentially continue on, but there's not as much managers or oversight, you're probably looking more like an LLC. LLC is kind of a mix between a partnership and a corporation. The biggest distinction is that you don't have shares like you would a corporation, but at the same time, you don't have the personal liability you would have of a partnership. So it has like a best of both worlds. So what's good about looking at that is, you're able to see like what are they trying to do. Another indication that you have an LLC as opposed to a corporation is in the fact pattern, if it mentions the name promoter or incorporator, that's usually used to discuss and talk about people that are trying to create a corporation, either a C Corp or an S Corp, or even a closed corporation, doesn't matter. A promoter is typically the person that is an agent of the corporation before it exists. Sometimes they're the same as an incorporator, sometimes they're not. An incorporator is the one that's literally trying to get this off the ground and start to open this business, this corporation. And then for an LLC, they're all called members. Okay, so it's really easy if you know the terminology because you might not have to go into a crazy analysis. Just see like what everybody's called. And obviously partnerships are usually called partners. If you have something that doesn't mention any of those, but it sounds kind of like a partnership, that seems more like a short-term type business for a certain time frame, then it could be what's called a joint venture, which is kind of like a mini partnership. And I call it a mini partnership because it's usually the exact same thing as a partnership, so all the rules of a partnership apply. The only distinction that you really have to know with a joint venture is it's typically on a time limit of some kind, okay? So, first question, what does this look like to me? And then ask, what is the intention of the parties here? After you ask that, you have to say, okay, what legal formalities have they done? So what this question is really going to ask you is, have they filed anything with the Secretary of State? Anytime a filing is required, it's almost always going to be with the Secretary of State. And with partnership agreement and with an LLC, they may file something like a partnership agreement or an operating agreement. That's a good indication that they might have those types of businesses. Almost always, an AIC, Articles of Incorporation, will be filed with an LLC, but a corporation is absolutely required to file an AIC. And the reason that is because most corporations, they're public corporations and they sell stock. AICs have to discuss what the stocks are, how many they're going to be selling. They might determine the value of the stock, or the most limited amount they would sell a stock for, all those things, all those intricacies. And if they do file an AIC and they list people that are supposed to be the board of directors or the initial board of directors, then you know for sure it's a corporation, because corporation is the only one that is structured in that way. No other organization has a board of directors in this small, narrow universe. Now, an LLC can also have an AIC, and it typically does because there's an election for LLC, but it's not as structured as a corporation. Corporation has a lot more hoops, if you will, you have to get over. So a corporation has to state, you know, who's going to be the board of directors, who the incorporators are, all their addresses, a registered agent, the name of the business, the purpose of the business, has to have the AIC. Once that's filed, the business is going to be created. It will have been born, if you will. An LLC is the same, but if you mess up a lot of the formal requirements of an LLC, as long as you file something with the state, you should be fine. You're supposed to have an AIC, but LLC is a little bit more relaxed, if you will. Corporations are a little bit more high strung because an LLC does not have a board of directors, does not have usually shareholders or stockholders. They might have contributors, people that pay into the business, help give it capital, but it's not the same thing. So think of it like this. The business that could have the most impact on the public is probably going to be a corporation, because they can sell stock and they could really influence like retirement plans, pensions, you know, investors and nonprofits that are investing in them, or just people in general that are trying to get involved in the stock market. So they have the biggest impact and they could really destroy the most, which is why they are going to be so structured. If you want a reason to kind of sink your teeth into, that's a good reason. Whereas an LLC, they have members, you know, you have contributors and stuff like that, but it's not going to be as intense. Now, if you're trying to figure out, okay, there's an AIC, so I'm either looking at a corporation or an LLC. They don't say anything about board of directors. They don't say anything about a member. They don't say any of that, but they specifically discuss stocks and a limitation on stocks. And they only have up to 100. Then you know it's an S Corp. So an S Corp, think of it like either short-term corporation or a small business corporation. That's how I think of it, because you know they can only sell up to 100 stock. In addition to that, the stock that they sell is going to be a little bit more limited, and the people that are governing it are going to be a little bit more limited on what they can do. So there's a lot more regulations because it's narrower, it's smaller, and that's why. So that's what an S corp would be. So just so you're aware, that's kind of how that would work. Now, you're probably wondering, okay, there is this really weird, narrow type of corporation. It's called a professional corporation. They typically can have a board of directors and officers and shareholders, and they typically do because they are a corporation. There is a lot of limitations on that, and not all actual states allow it. But if you see something that looks like a corporation, but they're mentioning specific licensing requirements, and everyone who's a shareholder, board of director, or an officer has to have licensing requirements in the same field, you know, it's a professional corporation. Think like a doctor office or a dentistry. If you're opening a professional corporation, you can limit personal liability. It's disfavored because of medical malpractice claims, and it's really regulated, and there's a lot of issues. So if a shareholder loses their license, they have to be removed. They can't be a part of it anymore, and it just causes a lot of problems. So you don't see it much. So the biggest structure, or the biggest question with structure, is the intent of the parties and what legal formalities that they have actually performed, and that will really help you figure out where to go from there. So I'm going to take a quick pause. I did. Sorry, I had to put something on my head because my bangs were driving me crazy. There's also somebody talking next door. They're very loud. I hope this mic doesn't pick it up, but if it does, I'm really sorry. Hopefully you can still hear me, so I will just talk very loud. Okay, the second step is going to be parties. So all you're looking at now is once you determine what kind of business it is, what kind of structure it is, now you're going to say, okay, who is involved here? Who are the parties? And this is really helpful because it kind of forces you to stop. A lot of people will be like, here's the structure. We have a member, LLC, moving on. But it's really best to take a pause and look at the parties and say, who are these people? Who is involved? Because it kind of helps you further make sure you don't skip anything and make sure you don't skip over the duties that are required. So when you're looking at parties, you need to look at, okay, who is involved, okay, in the corporation. Now, when I'm saying that, I'm not just saying like who is in charge of the every single day-to-day operation. That's important as well, but who is in this? Is it somebody that's in control? Is it someone who's just a basic manager? Is it someone that only contributes money? Is it someone that just gets paid money? What is their role in the organization, if any? And are they getting paid? And if so, what are they getting paid? So just kind of who these people are and everything that encompasses them relating to the business. That's very important. It helps you really distinguish what's going on. And the reason why it's important to see if there is any type of control is that might go into like other issues like master servant or agency law, because that kind of think of it like an umbrella that if nothing catches anything, that will always catch something for liability for the most part. So when you're looking at parties, ask yourself, is this a director, an officer, a shareholder, a member, a partner, an employee only? Now remember, if somebody is receiving any type of profit in a partnership structure, even if they're not an official partner, they will be deemed a partner. That's a general presumption. Okay. So just think, trace the money and who's involved and who has control. And the reason control is really important, especially for a partnership, is there are two types of partners. There's a general partner and a limited partner. A limited partner does not have personal liability for issues regarding the loss of a business if something were to happen. But a general partner does have personal liability that attaches. And a general partner is deemed to be the one that's in control of the partnership and the one that's in control of all of the decisions. So now remember, that is specifically for a regular partnership. Now we have like an LLP partnership that's completely different. No liability attaches there because it's just the nature of the agreement and the nature of the structure. So that's what you need to ask. Another thing you need to ask yourself is if there is somebody who is in control, always ask yourself this question, or just remember if they're an independent party. And what I mean by that is this somebody that is being manipulated by somebody else, or somebody that's using their position to benefit themselves? So they're not somebody that's acting in the best interest of the business. This goes across the board. It's usually looked at for directors to see if they're interested because they have a vote on what they do regarding business decisions, but it can be applied actually to anybody. And that will really help you with the duty when you're looking at like what applies. It's very important to see if somebody is in control, if they're a manager, if there's some type of operating agreement of some sort, or if they are, somehow biased in any way because they're just not independent regarding their actual role. Now, the next one you're going to look at is duties. There's a total of 7, and there's one subtype. So there are a lot of duties. Just know every single duty applies to a director. Almost every single duty also applies to officers, okay, when you're looking at a corporation. And there's only really one that applies to shareholders as well, and that's going to be the duty of, I believe it's just the duty of good faith. And that's specifically in the circumstance of majority shareholders, because we don't want a majority shareholder to take advantage of a minority shareholder and like freeze them out or make a decision in a way that they have nothing they can say or do. So a couple of cases have said that my majority shareholders just owe a basic fairness standard, and some have said that there's a duty of good faith. As long as you do something along the lines of mentioning the duty of a majority shareholder to minority, is just to make sure that they still have some level of say, or that they are making a business decision that is not for their own self-interest and it's not going to detrimentally harm the minority shareholders, or even if it does, that wasn't the intent, that wasn't what was happening. As long as you can argue that, you're probably fine. But that's the gist of it. Now, 7's a lot, so if you have a corporation, you have a lot to look at. And the reason there's so many is because they're fiduciary duties. So just know that regardless of what kind of corporation you have, regardless of the structure, there is always a fiduciary duty owed to somebody. And the most common fiduciary duty is the duty of care, duty of ordinary care, and the duty of loyalty. Now, remember, you can, in an operating agreement, limit a lot of fiduciary duties. You can even limit the duty of loyalty, but you can't get away from it altogether. It's still going to apply. And typically when you're contracting out of a duty of loyalty, it's only regarding like competition. So you can't really do anything to allow you to destroy a company and get away with these fiduciary duties. You just can't get rid of them. Now, when you're looking at duty of care, duty of ordinary care, and duty of loyalty, remember, technically duty of care has swallowed up the duty of ordinary care, but if it helps you to separate them so you don't forget what it is, then you can do so. That's kind of why I separated them. So duty of ordinary care applies to agency law and also to master-servant relationships. which is why I separated it so that I wouldn't forget about it if that came up. Now, duty of ordinary care is simply what would a prudent person do in this situation under the same circumstances, whereas a duty of care is the duty to have and not show, but like give. What's the word? Oh my gosh, I totally lost my train of thought. It was totally on it. It is the duty of care is the duty to have and not embrace. Huh. Duty of care is the duty to implement a duty of care, skill, and diligence that an ordinarily prudent person with the same expertise and background would in that same circumstance. So you can see how that second part is literally the duty of ordinary care. The biggest difference is the duty of care is really looking at the person who is in the position and then an actual knowledge expertise that they specifically have. Because the thought is, why would I hire or promote or put a director in a specific position that has, a doctorate in a very specific chemical engineering background, that has 20 years experience in that field, that, has additional PhD in mathematics, and I have this, very complex project management company that specifically works in chemical engineering issues. I'm going to expect him to use his skill and his diligence and his care that he has, gained from all of this background. I'm going to expect him to use all of the, the resources that he has available to him, based not just on him, but resources available to him that somebody in his position with his knowledge would also use. And that's where that second part comes in, is somebody in his same situation, with his same knowledge, with his same skill set. Would they have done exactly what he did, or would they have done something different? So that's the duty of care. Duty of care is a very big, very important one. That's the one that, that's one of the ones where if you breach that, it's kind of hard to have that get pushed under the rug a little bit, because you're really looking at the person. If you want to look at it that way, you're looking at the person more. Like, did they act in a careful way? Now, the next one you have is duty of loyalty. So I'm going over the most common, okay? Then I'll go into the harder ones. So the duty of loyalty is most simply you're loyal to the company, and we're going to assume you're going to act with the utmost faithfulness to the company, to act in a way that is within their best interest for the company, for what they need. That's what we're going to assume. We're going to assume you're going to do the absolute best to make the decisions in their best interest. We're going to assume you're not going to create any conflicts of interest. You're not going to, engage in any self-dealing. You're not going to try to compete with the company at all. You're not doing any of those things. You're not doing what is called usurping a corporate opportunity. You're going to be doing what's best for the company. Duty of loyalty is one of the most important ones. And just know, duty of loyalty is actually very similarly connected to the duty of good faith. Technically, duty of good faith comes from the duty of loyalty, but I separate them so that I don't forget it, because duty of good faith is like good faith and fair dealing, which is very similar. And we're just assuming that you're going to act within the best interest of the company again, that you're going to act for the company, what they need, not thinking of yourself. You are not doing things that are going to benefit yourself, put yourself in a better position. You're really going to be careful what you do to ensure that you're not harming the reputation of the company, and you're helping them grow and do what they're supposed to do. You're helping encourage their purpose. So they're very similar. But the biggest thing with good faith is, the biggest test of good faith is, did they act in bad faith? Did they do something that somebody could easily look at, any ordinary person could look at and say, that wasn't the right thing to do? It's pretty simplistic. I'm very oversimplifying. But the easiest thing when you're looking at good faith and fair dealing is, did they act in a way that was fair regarding the price and the process of their decision? And did they act in a way that's beneficial for everyone involved, specifically the corporation? And did they do anything that could potentially harm their reputation? So that's the duty of good faith. Remember, duty of loyalty and care are the most important ones. And they're the ones that are most tested, are also the ones that so the reason why they're the most tested is because if you fail in the duty of loyalty in any way, and I believe also the duty of care, the business judgment rule, which we'll get to, will not protect you. So that's why those are usually the most tested, because there's just so many more things you're going to be asked about. So now, when I say the most tested, if you're looking at duty of loyalty, so remember, duty of good faith kind of stems from loyalty, so that's probably going to be tested as well. Now, I mentioned there's a subtype. So the subtype actually comes from the duty of good faith, and it only applies to corporations. It's the duty of oversight. And so the duty of oversight, if you really want the most basic explanation, is did the director do his job with what he was tasked to do, how he was supposed to do it, in a way that was timely and professional, specifically regarding policies and procedures in place to protect the corporation. So, duty of oversight is, think of the director, he's on top looking down at the corporation. Is he doing his job and his due diligence? If the answer is yes, he can still be held liable for breaching the duty of oversight if he didn't instill some type of procedure or policy in place, depending on the state, or if there was a policy or procedure in place to monitor the corporation, to gain information about the business that he did not collect, he did not maintain, he did not monitor, he did not check on, and because of that, he cannot make the best informed decisions because he doesn't actually know what's happening in an internal level of the business. So when you have a monitoring system of a business, what you're really looking at in the business, you're trying to see like what is happening in the business. And there's a lot of reports that are involved. It's not like you're obligated to prevent any type of theft of the business or spying or violation of company policies or trade secrets. What you're really looking at is the director doing what he ought to be doing to make sure the business is okay. And the information gained from certain monitoring systems, is he using that information to the benefit of the company? If the answer is no, then he's breached the duty of oversight. So a great example of the breaching of the duty of oversight is the duty of oversight really is going to be specifically looking towards if there is something that's obvious on a report that they should have been aware of, like if they notice that, the accounting department has recently not been paying their bills, or the amount of money that's in their account receivables has drastically reduced and it's not being maintained, or when you look at the accounting payables, there's so much more going out of the business and coming in, something like that that's completely out of the ordinary. We would expect a director to catch that because that's his job. So anything like that, it's duty oversight. So that's the first few, right? Duty of care, ordinary care, duty of care, duty of loyalty, duty of good faith, subtype of duty of oversight. Then you also have duty of obedience, but I don't count that in the counts because technically it's been done away with. But the duty of obedience was simply, is the people in charge of the business, whoever they are they following the instructions of those that are in charge of them? That's it. It typically applies to agency law or to like officers. It's not really directors as much because they're on top of the pyramid, right? Now you also have a duty of accounting. This is pretty simplistic. This is really, are you keeping track of the money? What's coming in, what's going out? Are you just keeping track of that? Are you keeping the good reports? It's very simplistic, very easy. So pretty much are you keeping things separate? And then you have a duty of full disclosure or disclosure. So anything that you know about or ought to know, you receive that information, and as a director, you would expect to receive that information if your officer knew. And let's just say the officer never told you, that would be a breach of the duty of full disclosure. So full disclosure, depending on your position, requires you to share information either with other people in the business so they can make the proper business decisions, or requires you to share things with the public, like if it's a publicly traded corporation. Even if you don't need anybody to make a decision or vote on anything, the duty of disclosure would require you to share something that could potentially affect the shareholders, even if they don't have to do anything. You're just sorry, I have to sneeze. Sorry. A duty of the duty of disclosure is you're sharing information with publicly traded entity in a publicly traded entity that they ought to know in fairness. It's rare that you can it's a lot of people will sue under that, but it's kind of hard to prove because it's kind of a business judgment because they don't want to affect the value of their shares. And so there's a lot of things that might happen in a corporation they don't have to share because of that. So, that's how that works. So I think that's it. There is one more, but it kind of goes into good faith. It's duty of fair dealing. It's very similar to good faith, but when you're looking specifically at the duty of fair dealing, especially in situations where a shareholder is arguing that you took advantage of them, or the corporation did not pay what they're supposed to, or they made a decision that was an interested decision for the bias of somebody else. Fair dealing is going to look at the actual process that you went through to make this decision, who made the decision, if they were fully informed on the decision, and then if the decision was one that did in fact benefit the business, and if it didn't, is it still going to fall under the umbrella of a business decision that was made by unbiased individuals that were fully informed in a way that they felt was best for the business. So you're looking at the procedure of how they approved it, and then you're looking at the substance of the deal itself. So it's I kind of always remember it with good faith because it's just easier that way, but technically they're separate. So I think that's all 7. So why did I just go over duties? Because depending on who the parties are, changes which duties apply. So all the duties apply to directors. Almost all of them also apply to officers. Duty of disclosure technically on a publicly traded corporation is only for directors because they have to tell shareholders. In other companies, you could argue that the duty of disclosure does apply, but technically, duty of disclosure does end up getting engulfed in duty of loyalty and care. So that's how that works. So if you have a corporation analysis and it's a public corporation, just list all 7. And then the extra subtype under good faith because it's just easier that way so you don't forget. Partnerships, the most common that you're going to have is duty of care and duty of loyalty. You can have other duties as well that might pertain to it, but those are the most common that you're going to have. I would say almost every single business one, duty of care and duty of loyalty are the most important. But if you have any big decisions that involve maybe an accusation of self-dealing or personal bias, then you should always do the duty of fair dealing, potentially if the decision was made and there was an accusation of that. That might be helpful. But for the most part, if you have duty of care and duty of loyalty, you're mostly fine. Because usually when you talk about duty of loyalty, you always talk about the duty of good faith anyway. And good faith does apply, obviously, to all of the businesses because, you're going to be assumed and presumed to be wanting to act to the benefit of the businesses. Okay. Now, the fourth one I have is what happened. And the reason I have you do duties first is because you can see which ones apply or which one were breached, and it's easy on an analysis because then you can say, here are the duties that they're obligated to abide by. Here's the ones they breached with this occurrence. So I think it's easier that way. So I have what happened or the injury, the occurrence. Why is somebody upset? Or, is somebody suing? So usually when I look at that, I say, what happened? The second thing I guess I automatically go to is, did anybody vote on this? Because in partnerships, if you have more than 2, there's a vote, and people have to vote on what they want. It's a majority. If it's a board that's voting on something, they need a quorum, which is also a majority of people there. If it's a shareholder that voted on something, they also need a quorum. They need a majority. If it's LLC members, they also need a majority. They need a vote. So who voted? Was there a vote? How many people were there? And the people that did vote, were they interested parties? Were they fully informed parties? And did they do this based on what they thought was best for the business? Very important, very specific, but it really helps you figure out where you need to go in your analysis after the fact, which is why I think it's important to always ask. Now, once you've determined that, then you can go to, okay, based on what happened, was there a breach of a duty? And if there was a breach of a duty, if that thing that happened falls under what is called a business decision, which required the use of business judgment, which required the analysis of all the information to determine something to make the best decision for a business, then even if there was a breach, a lot of times it will not be something that can be held enforceable or valid because of the business judgment rule, because the business judgment rule specifically protects business decisions in the course of a business without the benefit of hindsight for judgments required for business operations. If something was done for the business that did not require judgment or discretion or the analysis of additional information, the research of additional information, then it is not a business decision, so a business judgment rule would not apply. Now, if the business judgment rule does not apply because of this breach and the nature of the breach, then potentially fairness rule would apply. So, equitable fairness standard is what is used to figure out if what happened within the business was acceptable. And it actually uses part of the fair dealing standard. And pretty much what it is it looks at what what was discussed, did the business decide what they were going to do or what they wanted to do, and how did they end up doing that thing. So literally, again, equitable standard or equitable fairness standard is the process that the people in charge did, and then how they decide to implement it and the terms of that thing. So literally, it's process and substance. That's it. Now you're wondering, well, how can a business judgment not be protected by the business judgment rule if the plaintiff argues that there was fraud or illegality or bad faith or anything like that? Business judgment rule will not apply. And if that is what is pled, then it's actually going to be a burden shifting kind of thing, where then the people that have been accused of doing the wrong thing and engaging in fraud or something, they'd have to prove that they did not, and then they'd have to prove under equitable fairness standard that they did something that was fair and it was equitable and it was in the best interest of the business, because the process with which that they did this thing and the terms of the agreement were completely fair. Now, remember, process is going to be, okay, if I found this amazing opportunity, but I think it's an amazing opportunity because of the business aspects of it, but also my cousin is the one selling it, that would make me an interested party. So I go and tell the rest of the board, and they host a vote. And the majority of the board members that were fully informed about this opportunity, they were fully informed about the fact that it's my cousin. That's how I heard about it. And then they did extra research about the area, and maybe even they brought in additional people to figure out if this is a good opportunity or not. Then technically the process was fair. The terms were fair. They were based on what we were already looking at doing as a business. Just because I got an opportunity by somebody I knew from a personal relationship, that doesn't mean that what was done was wrong. But you have to prove it under equitable standard because of that. And also, depending on what happens, you might even have to have what's called a special litigation committee. If it gets to litigation, you have to have the SLC. It's easier, Special Litigation Committee. And those are just people that come in to either help you before you make a decision, but typically it's after you've already been sued, because it's SLC. And so they're going to look at the decision you made, the information that you had, the research that you did, and everything you performed in the process of deciding whether or not to take on this opportunity. Then when you do take on the opportunity, all the terms are related to that specific agreement or decision that you made. So that's how that works. Then next, you do liability. So liability is important because it really is going to be dependent on if you've done the first part right. If you did the wrong analysis in step one, the rest of this is messed up anyway. I'm not to scare you, but pay attention. So liability is going to be whether there is personal liability or there's liability on a corporation or on a director, for example. So typically, if it's an LLC, LLP, or a corporation, S corp or C corp, there is no personal liability that will attach to the actor that did the wrong. Unless we can do a few different things. Tort liability almost never is going to be completely protected. If there's a master-servant relationship under the doctrine of respondent superior, either because it's an employee relationship or it's an agency relationship, the principal will be held liable, or the employer, or depending on the duty that was breached. Sometimes duty of loyalty and duty of care, if it's breached because of self-dealing or competition, sometimes the court will actually hold the director personally responsible. However, if that happens, you have to look back towards the AIC, the Articles of Incorporation, to see if there's any limiting doctrine that's been mentioned that says that they limit the personal liability of directors, because technically they can do that. And if there is a limitation there and they get sued for, say, $2 billion and the plaintiff wins, the director's only going to have to pay a small portion. The rest of it's going to have to be paid by the corporation because they're required and obligated to indemnify the director in that instance. Now, remember, partnerships, they're always going to be held personally liable for anything regarding the profits or the losses. Now, if you do have a closed corporation or a corporation of any kind, or even an LLC, and they say, "Oh, you can't sue me personally because, I am the, member of an LLC." Well, you can always get to personal liability with what is called piercing the veil. So technically, piercing the corporate veil is a doctrine that applies to corporations, but a lot of corporation doctrines now apply to LLCs because they're very similar, and LLC is kind of new. So piercing the corporate veil, or just piercing the veil, is where they pretty much say, although you're a corporation, we are going to remove the protection of liability to hold you personally liable because you have not faithfully ran this corporation according to the legal standards and formalities. Therefore, we're going to hold you personally liable. Now, there are a couple questions to ask in that analysis, and the most basic is there an alter ego, meaning that this person and the corporation are acting pretty much one and the same? Is there a unity of identity? Same thing. Are they abusing the formalities of corporation, meaning they don't have separate accounting? Their personal stuff is mixed with their business stuff. They're using the corporation as like a shuffling yard where they just put money here, put money here, put debt here, but it's all actually connected to the same person. If you look at this and say, this is really not a company, this is just somebody that's abusing it for the tax purposes, everything's actually connected to him, he's using the corporation as an alter ego of himself to commit fraud, then we're going to pierce the corporate veil because it will lead to injustice, and that's not the public policy we're trying to encourage. But you have to be able to show those things to do so. Now, remember, when it comes to liability for agency law, that's going to come from actual authority, apparent authority, or inherent authority. Get into that later, but the purpose there is the principal is liable for the actions of the agent. Now, the last step is remedies. So depending on what happened, you might have a remedy. Obviously, you have a direct suit. So this is going to be on behalf of shareholders. So a shareholder sues the corporation. Now, a direct and derivative suit are very similar, and they can get easily, confused. A direct suit is when a shareholder is suing because he has been injured, and if he wins, the money comes back to him. A derivative suit is a suit that is brought by the shareholders on behalf of the corporation. That's where they are arguing that the corporation has been injured, and if they win, the corporation gets the money. Now, if it's a derivative suit, remember, there are more requirements. You have to give notice to the board of directors, a chance to cure or fix what they did, and the directors actually get to decide whether or not they're going to bring this suit. If they decide not to, that's a decision that's actually protected by the business judgment rule, unless you can argue, one, they didn't give notice because it was futile because everyone is in cahoots, or two, you could argue that there was some level of illegality or fraud or bad faith because it had to do with self-dealing. If you can't argue that, then it can get thrown out. So just, be very, very careful when you're reading the fact pattern, like what's going on, so you make sure you don't miss anything. Obviously, then you have damages. Damages with personal damages. So when you're looking at damages, you're looking at, did somebody steal money from the business? If they did, they have to pay that back. Or if somebody committed a tort, sometimes you can sue them for that. Also, what's very interesting is if somebody lost an opportunity, they could potentially be held liable for that too. So damages is just anything to make the corporation or the business whole. Sometimes, so in a partnership, for example, a partner can sue either the partnership or the other partner because all partners are going to be agents of the partnership. So they can sue each other for certain things that they did that they felt was outside of their reach. The most interesting one is called disgorgement. So if I take an opportunity away from the business that should have gone to the business, that came to me because of the business and my affiliation with the business, but I took advantage of it anyway without telling anybody, any money or profit I make from that, they will literally just take it away from me. And a corporation, for example, it's called the corporate opportunity doctrine. If an opportunity came to the corporation and I took advantage of it and I didn't tell anybody, what they'll do is they will take all of my profits and they'll put it in what's called a constructive trust. And once all the money's been collected, then it will be dispersed to the corporation. And the only way around this is if you first give notice to the board of directors about this opportunity and they either vote to not take advantage of the opportunity or they're not in a financial place to do so. Or another one is if it's not even within their line of work, they probably wouldn't anyway. There is actually two doctrines that can apply. Well, not doctrines, I guess, types of law. You have the Ali law and then the Delaware law. Delaware law says you do not have to disclose an opportunity. but you should. And if you do disclose the opportunity, then you can't be held liable for taking advantage of the opportunity. Ali says, that case says you have to disclose the opportunity. Now, it's going to be a harsher interpretation if the opportunity came to you because of your affiliation with the business. But if it came to you because of a personal affiliation, nothing to do with your business affiliation at all with this corporation, then it's not going to be as harsh. Obviously, a disassociation, that's more going to be for a partnership or an LLC. Disassociation for either does not necessarily mean that there's going to be a disillusionment or a destructive demolition of the business, but it could. More likely in a partnership, because if you have two people and one person leaves, it's not really a partnership anymore. So, but remember, disassociation can be forced. You can be voted off. You can be told to leave. You can be requested to leave. Your time there could have ended based on contract agreement, based on the operating agreement, or you can leave at will, or you can leave unlawfully before your contract term. So disassociation is also something that a court can do as well. It just depends. If there is a dissociation, if it leads to what's called the winding of the business or the closing of the business, that's called dissolution. Or if people are just not getting along, they can ask for disillusionment, which is technically a remedy. And if there is a dissolution, that's just where the business is no longer going to be in existence. When that happens, the business, regardless of what it is, can continue to operate for the going concern of the disillusionment. And all that means is the business is allowed to continue until all of the debts and obligations have been settled and paid, all the accounts have been settled, and all the assets have been liquidated. So there is a priority, and typically the priority is creditors first, and then partners or directors or anybody involved in the business that has contributed for a loan, not actually capital contributions. Then after that's capital contributions. Then depending on the business, it's shareholders. And if there is no shareholders, then it's just the disbursement of the remaining asset value. There are the ability to have an injunction, which prevents them from doing something. Or there's a remedy of accounting. That's more specific to a partner, where they will require you to show all of the reports, all the money coming and going, to prove that you're not stealing. Another note on disillusionment. For a partnership agreement specifically, if you wind up a business, technically the creditors get paid first, and then the partner loans get paid next. But some courts have said that they're at the same level as creditor. Other courts have said that they're not. So that's one of those things where you'd have to say, depending on state law, it would be them paid, then partners who gave loans, or they'd fit into all creditors and get paid first. So these are just different remedies. I believe another remedy would be to, one of the other remedies in agency law would just be that they don't enforce a contract that was made, or they actually invalidate an action. So they won't support some type of contract that was made or decision that was made. But that's the gist of it. I mean, there's obviously a lot more. This is just a brief overview, but the biggest thing to pay attention to is what type of business it is, who's in it, what duties will be owed, what happened, were those duties violated? If so, can we get around it? Depending on the business, can we get around it with the business judgment rule? Or if not, like, what liability is owed and to who? Can we get away as well from liability? And then what are the potential remedies after that? So just pay really close attention to things. And do note that when you're looking at different structures, that at the end of the day, if you're not super sure, it's always good to argue an alternative. But if it's two or more people, that's it. It's probably a partnership. If it mentions the name member, it's probably an LLC. And if it has a lot of people, AIC and a bylaws, that's typically going to be more likely a corporation. And I believe that is it. Yeah, hopefully you do well.